It's just a sentence I want to read from there, but it really puts it in encapsulated.
Where is that compilation?
What is the compilation? It's called SCC. Part two of my compilation. It was filed with the note.
Oh yes, convenience compilation.
Yeah, these are more inconvenience than convenience, I agree with what, but they're always for some reason called.
It is, it's
a page 141.
Is it the supplementary convenience compilation?
Yes, that is the
convenience
supplementary.
477 pages.
141, if my lord said. Page 141 of the compilation.
Page?
Page 141 of that supplementary compilation.
Page 144 PDF.
Yes.
Definition, it says, statutory definition of arbitration agreement. This is under the English Act, no doubt.
PDF page.
It says definition in the 96 Act.
140? PDF page.
My lords have that. Section 6 of the Arbitration Act 96, that's the UK Act, contains a definition of an arbitration agreement. It provides that an arbitration agreement is, quote, an agreement to submit to arbitration, present or future disputes, whether they are contractual or not. And then the next sentence. An arbitration agreement is therefore a contractual undertaking by two or more parties to resolve disputes by the process of arbitration, even if the disputes themselves are not based on contractual obligations. I would adopt the same submission for our section 7.1. The agreement is a contractual undertaking. The disputes themselves may be contractual or non-contractual. There may be family matters, partition. But to go to arbitration, there must first be a contract. It's not that every family dispute without an arbitration agreement can go to arbitration. There has to still be an arbitration agreement. Similarly, for all the other examples that fell from the bench, torts, quantum meruit, quasi-contract, it requires an arbitration agreement. Now, the fact that an arbitration agreement has to be enforceable in law and therefore a contract, there are several tools that we get from the mathematics of our own. The most important tool to my mind is found in section 28 of the contract. My lords know section 28 of the Contract Act renders void any contract in restraint of legal proceedings.
Exception is an exception.
Exception, and it's referred to as a contract.
One point of distinction so far as the UK law is concerned, they have a separate statutes with respect to rights of third parties.
Yes.
So therefore, that's the point of distinction.
My lord,
our law in the English.
So do we, and our act deals with that. I'll show that provision also. My lord is actually statutory arbitration. We also have. If my lord sees section 28, agreements in restraint of legal proceedings void, and exception 1. I'm sorry.
Yes.
Exception 1. This section shall not render illegal a contract. Please mark those words. A contract by which two or more persons agree that any dispute which may arise between them in respect to any subject or class of subjects shall be referred to arbitration. So it has to be a contract, otherwise it will be hit by section 28. And contract in the Contract Act is well defined. That is an agreement enforceable at law. How is an arbitration agreement enforceable? And which is the law that enforces it? It's the Arbitration Act. Because under the Arbitration Act, one can enforce an arbitration agreement either by filing a Section 8 application or a Section 11 petition to your lordships or to a high court. And the resultant enforceable agree Section 536. Similarly, a foreign arbitration, the foreign award is enforceable under 46, 48. So it's enforceable at law. It's enforceable under the provisions of the Arbitration Act itself. And therefore, it is a contract. And if it weren't a contract, it would fall foul of section 28 of the Contract Act. So it has, and my lords have repeatedly said And I'm not, my lords are familiar, I'm not citing those judgments. I've referred to a few of them. Vidya Drolia is the last expression of that it has to be a contract, meeting the requirements of the Contract Act. Your lordships, in Bhavan construction, a judgment I put at page 128 of this, Justice Roy was a party to that judgment, also says that arbitration is a creature of contract. Correct, absolutely correct. And then if my lords go to page 3 of the note, running through it, all the material here, I don't want to trouble my lord by actually reading everything. So, para 13, I've cited the US Supreme Court. A party cannot be required to submit to arbitration any dispute which he has not agreed to so submit. And it refers to it as a matter of contract. Then Russell, I've shown my lords. And Gary Bourne also says this is a contractual method of resolving disputes. So there can be no doubt that an arbitration agreement has to be a contract. Otherwise, it's meaningless, not enforceable. It would run into the restraint of Section 28. The disputes that can be referred under that contract can be non-contract, no question. Tort, family disputes, even IPR disputes of a certain nature, all that can be. And then at page 3 of my note, I've now analyzed what are the requirements under the Contract Act of a contract. The first is, your lordships in have said this, that mere acquiescence is not enough. There has to be an offer, acceptance, a proposal, and acceptance. And therefore, there has to be reciprocal promise, there has to be an absolute and unqualified acceptance, which has to be expressed in a usual and reasonable manner. Why am I emphasizing this? Because as far as the signatories are concerned, they've signed. That's the acceptance. There's no dispute on that. As far as the non-signatory's acceptance would have to be established in a manner known to the law of contract. That doesn't mean signature. It can be by conduct also, because acceptance can be by conduct. There's no difficulty on that. But it has to satisfy the threshold of what constitutes acceptance under the contract. Now, all this actually does tie in with the group of companies doctrine. I'll come to that finally. It's not that this takes us away from it, but it definitely requires a scrutiny of the factors that satisfy the group of companies doctrine through the lens of the contract.
Mr. Kambata.
Yes.
This group of companies doctrine and define legal relationship
Logic.
and a non-signatory. When you talk about group of companies, there are promoters for a company. Promoters may not be taking a decision for company X.
Logic.
But the promoters are of company X, Y, Z.
Yes.
Now, perhaps an attempt is being made that the promoters who might have been, looking at the promoters, people might have entered into contract with, say, company Y.
Yes.
Promoters are also being roped in who otherwise have no connection, nor they are seen.
Correct.
So, what is the interplay? Perhaps in a company situation, there's a board of directors which take the decision.
Logic.
Would you like to sort of?
Yes, Manoj, I think that's a very good question. And may we go straight to page 7 of this note. I've actually addressed this very issue. Fell from my lord on the last occasion. Therefore,
That's why it was.
I have addressed it, not specific. We can go to it straight away.
No, you may go in your own flow, but
I don't mind going to it straight away.
No, you may go in your own flow and then come to.
Very good. I'm certainly going to address it.
Right.
It's a very important aspect. You know, coming back to where I was there, 24 of my note, para 23, consent as defined under section 13 of the contract. Two or more persons are said to consent. We agree upon the same thing in the same sense, consensus ad idem. So in the para 24, I've tried to summarize. In the context of the group of companies doctrine, one, there must be consensus ad idem. That is a mutual intention on the part of all parties, both signatories and non-signatories, to be bound by the arbitration agreement. Two, there must be absolute and unqualified acceptance by the non-signatory. 3. This acceptance may be expressed or implied. Usually in the context of group of companies, it is likely that the acceptance will be implied. Such implied acceptance manifests in negotiations, performance, and termination, if applicable, of the contract. And that is why my lords in the ONGC discovery judgment have added a very critical fifth factor to chlorocontrol. It was not there in chlorocontrol, it's performance. That is a fundamental factor. Then 4, such participation in the contract through negotiations, performance, and termination, if applicable, must absolutely and unequivocally show the non-signatory's acceptance of the contract as a veritable party to the same. In other words, and this is put very well by William Parr in a passage cited in Cox and Kings, where he says the fact that a non-signatory might be bound to arbitrate does not dispense with the need for an arbitration agreement. It only means that the agreement takes its binding force through some circumstance other than the formality of signature. So you still need a contract, but you need not have a signature, because you can say that a party has orally agreed to an arbitration in writing, if it is undisputed and proved, or by its conduct in negotiation, performance, taking on of obligations, has effectively and impliedly consented or accepted that arbitration agreement. So I'm not for one moment suggesting that this argument excludes the group of companies doctrine. Of course not. But this is now my alternative argument, that even if space is found within Section 7, there are still certain cardinal limitations. And the reason why I'm emphasizing this is that our country, India, has actually gone to an extreme with respect to the group of companies law. We see the law from all over the world. It is hedged in with guardrails and restrictions. India is perceived as they call it, the most liberal as far as this doctrine is concerned. Now, that's not a bad thing in itself. One must keep in mind that going to one extreme will also open floodgates. And India will thereafter not become attractive as a seat for arbitration for example, a group or a foreign multinational or even an Indian multinational, with companies where it wants to have a structure where ring fences certain companies with the contract. They have nothing to do with the contract. But because of the manner in which some of our High Court decisions reached out, any credit-worthy member of the group is brought into the arbitration. So that is, my endeavor is to satisfy my lords that there is need now for some guardrails to be put on the chlorocontrol doctrine. It cannot be unrestricted or unqualified. That is actually something that works against arbitration. Because the general impression of the other side is, group of companies doctrine, pro-arbitration, we must propound it. No doubt about that, but with certain guardrails. Only then will it become an effective doctrine. And guardrails to the extent that it cannot intersect and be destructive of other very well established, like the right of a corporate group to structure itself, short of fraud, circumvention. I'm obviously not talking about those cases. Those cases, my lords have always been able to look through, always pierce the corporate veil. So fraud, deception, circumvention are out. But short of that, there's no reason why, as in tax planning, one can't arrange one's affairs. The whole line from our Constitution bench decision in Dunlop, and then as explained in Azadi Bachao, saying there's no reason why you can't organize your affairs. Now, giving unrestricted vent to the group of companies doctrine will ride a coach and forth through all those other doctrines. Therefore, the doctrine of concluded contract will go. The doctrine of structuring your affairs in a particular manner will go. The doctrine of party autonomy and consensual nature of arbitration will go. If the group of companies doctrine is interpreted as so far-reaching as to reach out to any part of the group. And that's the reason why I would submit that it is necessary for your law now to lay down this stuff. It's not enough to say that there are judgments Supreme Court and that's enough, which is what my learned friends say. No. So when we see those judgments, and I'm not going to trouble my lords with those, everyone has read those, they don't have these guardrails. They are even chlorocontrols. For example, chlorocontrol is the most important guardrail of performance. It's not there in chlorocontrols. So it is necessary. Now, may I just show your lordship judgment in ONGC and discovery, which is in my main compilation at page 838. The first compilation that I filed, volume 1.
Just one second. कहाँ पर होगा?
Page 1.
Yes, that yes. At 805. Forty 41, which started running page 845.
One second. Just still.
Violations that you have
I
filed
filed.
in your office.
One
What
is the
page?
long one,
805 PDF.
with what 1500 pages.
Yes.
And then second is yesterday's.
That's
The length is only because we put in the entire document.
Convenience compilation. Yes. Page 805.
805. At 845 is para 40. It actually neatly summarizes chloro controls and adds one factor. So at the bottom of page 845, in deciding whether a company, whether within a group of companies which is not a signatory to arbitration agreement, would nonetheless.
Just one second.
I'm sorry.
PDF 849.
Para 40 and page 845 of the compilation.
Yes.
May I read that?
Yes.
In deciding whether a company within a group of companies which is not a signatory to arbitration agreement would nonetheless be bound by it, the law considers the following factors. 1. The mutual intent of the party. 2. The relationship of a non-signatory to the party which is a signatory. 3. Commonality. 4. Composite nature of the transaction. And qualify the performance of the contract. This last factor was not referred to in Floribel, but it's a critical factor from all the authorities, because it is this that would make the non-signatory a veritable party or give unqualified implied acceptance. And then para 41. Consent and party autonomy are undergirded in section 7 of the 96 Act. However, a non-signatory may be held to be bound on a consensual theory founded on agency and assignment, or on a non-consensual basis such as estoppel or alter ego. Now, I'm not dealing with these because I believe my lords are really looking at the group of companies law. These theories are well settled. I'm not addressing on these theories. But when my lords say consensual theory, that necessarily means consensus ad idem under the Contract Act. Now, there are two important documents which I've put in my, sorry, take my lords back to this short compilation, the recent one. The first is a report of the Secretary General of the UN. That is found at page 198 of the short compilation. It starts at 194, sorry, page 194, but at 198. At 194, we see it is a United Nations Commission on International Trade Law, Settlement of Commercial Dispute. Topic is requirement of written form for arbitration agreement. And if we go to 197 first, Para 12 gives various fact situations where parties may be said to have agreed to an arbitration clause. In 12, we see is a number of situations, different types of situations. And if we go to the next page, M, where a claimant seeks to initiate an arbitration against an entity not originally party to the, or where an entity not originally part of the arbitration agreement seeks to rely on, initiate an arbitration, for example, relying on the group of companies theory. And if my lords kindly see the footnote, footnote 1, the group of companies theory has been used to bring a parent company or a subsidiary under an arbitration agreement, which has not been signed by other members of the group. The theory may be summarized as requiring that the legally distinct company be brought under the arbitration agreement, group of companies that constitutes one economic reality. 2, that the company played an active role in the conclusion and performance of the contract. Active role in conclusion and performance. And 3, that including the company under the arbitration agreement reflects the mutual intention of all the parties. This concept has been applied in a number of arbitrations. For example, those some jurisdictions have rejected even this. But this is the UN law, and then my lord, a very, very instructive law by Ahmad, which is found at page 208 of the same compilation. And for about 50 pages, he conducts a review of all the jurisdictions, 2020, including our courts. And at 258 to 59, our conclusion have placed before my lords is my signature. 258. I'm sorry.
258 will be part of the same article.
Same article. The conclusions in the article. It's para 487 onwards.
258, is it?
258.
269.
261 is the PDF.
Section 4 conclusions. It's just 2 pages, and may I just, because he's really summarized the document. It is very difficult to draw general conclusions from the above survey of the case law. Extension of the arbitration clause to other companies of the group, non-signatory in France, And still today, its courts and arbitrators are amongst the most innovative in the development of this jurisprudence. On the other hand, Swiss courts appeared in the first place, extremely reluctant to accept the extension of an arbitration clause to non-signatories. But the Swiss Federal Court has considerably relaxed its jurisprudence. The German approach still appears very restrictive. The courts approach in Holland, Russia, and the People's Republic of China. This seems to be also the position in England, where the so-called doctrine of group of companies is set to with the principle of privity of contract, the principle of corporate, the treatment of derivative acts. Moreover, the principles of lex mercatoria are not part of English law. The issue of who is a party to the arbitration clause is therefore mainly viewed as an issue of consent, but extension may nevertheless be achieved by recourse to such other theories as agency, trust, or in the corporate. The same theories are also applied in the US, which to some extent appears to be one of the most liberal jurisdictions with respect to the extension of the arbitration clause to non-signatories. India being definitely the most liberal of all. Then para 488. Subject observations. A first conclusion may be, now we're not, in the subsequent paragraph, identified 9 factors that, or 9 points that he identified.
I think it's cyclical, you know. We took a beating in ONGC versus SOPI. And therefore, you know, we have now turned the pendulum. Incidentally, who was reversed in ONGC versus SOPI?
Justice Ilse and then Justice.
No, it was my judgment which was reversed.
Oh, okay.
I had upheld the award and I was reversed by the Supreme Court. I was reversed in ONGC and I was reversed in Vodafone. Vodafone still holds the law.
I think the Supreme Court in ONGC SOPI was Justice Pensy and Justice upheld my laws. Then it went down.
Sorry. I was reversed when there was a young law student from one of the national law schools, and she called me up and said, I want to interview you about ONGC SOPI. So why on earth would you like to interview me on ONGC versus? Because you were reversed. I said, good heavens, judges have nothing to do with how you feel when you are reversed or something.
That's right, exactly. Exactly. Your lordships, I say, well, once your lordships write a judgment, then it's not. I mean,
I was sitting with Justice Pandya of the Gujarat High Court. He had just been in Pandya. He was our acting chief justice.
That's right. Your lordships were sitting with him for quite some time. Even the BPT rent was by your lordship.
He was the ACJ who swore us in actually when we came. That is Justice Khanvilkar and I in 2000.
The law student might have been thinking.
Some culmination, which I then used to get TRPs. Here, I've identified 9 factors, and each of them is very instructive. He really summarizes the whole theory in my respectful submission very well.
In this article, has he identified any points of distinction in the law that is applicable to India and other countries? It's clear that, you know, there are certain aspects which are distinct.
No, that's
contract as well as an more particularly contract.
My lord is right. Therefore, 487, he's already given the seat. So English law is very strictly will never accept it. So they've rejected it.
It's because they have an act.
No, that is because they rely on their common law principles of contract and they jealously guard those. So they said there's no scope for an exception to those. And they see the group of companies doctrine as some kind of an exception to those doctrines. Even the US, I'm going to point out a nice article, my lord, where I cited a number of theories.
And Dow specifically referred to performance.
Yes, absolutely.
That extract from Dow, which Hanitu has quoted, just at the bottom of page 258. Again, just to go back to that.
Correct.
The question whether persons, I presume that's the citation from Dow.
Dow, yes.
Dow. The question if the agreement can take advantage of arbitration clause therein. is a matter which must be decided on a case-by-case basis, requiring a close analysis of the circumstances in which the agreement is made. So making corporate and practical relationship existing on one side and known to those on the other side of the bargain, the actual presumed intention of the parties as regards the rights of non-signatories to participate in the arbitration agreement, and the extent to which and the circumstances under which non-signatories subsequently became involved in the performance of the contract.
Sir, I'm corrected. It's not Dow, it's some other.
Not Dow.
Dow also has similar
It's
language.
not
talks
Dow,
about
it's about
footnote
But there's similar language. in that.
512 says 30th November 1998, published, unpublished. See also ICC case number.
In fact, now there is a very strong move for publication of awards
Yeah.
because of all this.
to add some
But
transparency.
then, of course, confidentiality is the factor that was
You can
a.
always redact and
That is the move that most institutions are now making. But let's try the ninth. First is, as my lord has said, in that extract, actual or presumed intention of the parties as regards rights of non-signatories and subsequently became involved in the performance of the agreement and in the dispute. Both.
actual or presumed
Actual or presumed intention of the parties as regards the rights of the non-signatories to participate in the arbitration agreement. And the extent to which and the circumstances under which non-signatories subsequently became involved in the performance of the agreement and in the dispute arising from it. And that's why it has to be on a case-to-case basis, because each case will be a different.
But which are the 9 factors?
Yeah, so, well, I have taken this as one factor, but my lord is right. There are probably 2 in here. It's intention as well as performance and dispute. So that's really 2 factors there. Then 489, a second related conclusion is that arbitral tribunals do not often base their decision to extend the clause or not on a prior determination of the applicable law. Even if they do determine the law applicable to the contract and or the arbitration agreement, that law does not necessarily play a major role in the final determination of the non-signatory issues. Starting from the principle of autonomy of the arbitration clause, arbitrators generally feel free to determine their competence according to what they consider to be, on the basis of the facts of the case, the common intention of the parties, also taking into consideration usages of international trade. So that's really the same as intention, common intention. Then 3, there is also an agreement that the existence of a group of companies is not per se a sufficient element to allow extension to a non-signatory of an arbitration agreement concluded by another member of the group. This is a very important doctrine. Because often tribunals, I've found, they see a group and they say it's a group of companies. We just draw in whoever we want from that group. That's not enough. A number of other factors work on that decision. So they say existence of a group is not per se a sufficient element. Then 491. In most cases, courts and tribunals require proof of the existence of an intention, at least implicit, of all the parties that the non-signatories be parties to the underlying contract and its arbitration clause. Some courts, however, limit themselves to an awareness of the clause and the requirement that the additional claimant or defendant be concerned by the dispute. But the company concerned must always have played a role in the conclusion and performance of the agreement, and this has to be proved by the party requesting the extension of the clause. And beyond actual or implied consent, many cases are also simply decided by reference to other theories of civil or company law, and that's the first. That is agency, piercing the veil, etc. Then 492. The analysis of the arbitral awards also leads to the emergence of a rebuttable presumption that a parent company binds its subsidiaries. But that, however, only companies that have participated in the conclusion and performance of the agreement will be bound by the contract and the arbitration clause. This rebuttable presumption is quite similar to what our Supreme Court said in Vodafone, that even if it's a wholly owned subsidiary, you still have to show control. But it's a rebuttable presumption that you will have control with your shareholding. But that's not enough. You still need to show the subsidiary participated in the conclusion and performance. Then 493. Various other elements equally play a role in the decision to extend the clause to a non-signatory. First bullet. The fact that the other party has obviously entered into the agreement with the group as a whole and did not really care which companies would be involved in its performance, assuming that the determination of the signatory companies only concerned the details of performance of the contract. That's straight from Dow. They didn't care which part of the Dow group was the actual signatory, because they were dealing with a number of Dow group companies. Or the next bullet point, the fact that all the companies concerned have participated in the rights and obligations of the contractual relationship, in what is sometimes been called a total confusion. So there must be rights, there must be obligations of the non-signatory. He can't just be drawn in because he's part of a group. And then if we go straight to para 496, 494 refers to lifting of the corporate veil. 496, arbitral tribunals and courts have also emphasized the right to use a group structure as appropriate. But once a choice has been made, it must be fully assumed. In this respect, the use of a company vehicle for tax or other reasons is not per se an argument to justify lifting the corporate veil and, for example, extend the arbitration clause to the underlying shareholders as additional claimants. This is again very much part of our law. As I said, in Azadi Bachao, Vodafone, they've all respected this. If there's fraud, circumvention, of course, but not otherwise. And then 497. It seems that at least in a number of cases, a good test to decide whether an extension of the clause is appropriate is to determine whether the same solution would be justified if the situation was reversed. In other words, it is tentatively suggested that the principles used to determine the eventual extension of the clause to additional defendants might also be applied with some caution, however, when the case concerns additional claimants and vice versa. In fact, in Dow, it was the non-signatories who sought to be joined as claimants. So when a tribunal says, group of companies doctrine, this company A, we are joining as a defendant, it must apply its mind. Would we have allowed it to come in as a claimant? Same test must apply. And it has to, because even when you bring in a defendant, there can always be a counterclaim. So it has to be a reciprocal test. It can't be that you just look for the most asset-rich company of the group and go for it. Would you have allowed that asset-rich company to have filed a claim against that claimant? That's a good test. None of these, it's not, he doesn't say that each and every one of these factors has to be met. But he certainly suggests that a large number of these have to be met. And merely being part of a group is not enough.
Actually, I'm not sure the performance in all cases is necessary, because it could be that, a party, for instance, says that, look, you enter into a contract with my subsidiary. I'm the developer of the software. I'm the creator of the technology. And therefore, my subsidiary is basically going to be selling you what I have created and I have developed. So the third party who enters into the contract, the contracting party which enters into a contract, relies on the representation which was held out by the parent. Eventually, the parent may just step back and say, look, I have not participated in the contract.
Yes.
So the claim really is for breach of the
representation
obligations.
Correct.
Then in which case, the fact that the parent did not participate in the performance of the contract may not be itself very
exquisite. But therefore, that's where, in fact, there's a good article which my father has read.
So these are circumstances. In my I'm not sure whether they should be treated as cumulative, because then we unduly risk.
No, of course not. Of course not. That's not the submission. But a large, the test is really, does it meet the Contract Act threshold for implied? If it does, then the contract. It may be that in a given case, just one of these is enough to constitute implied acceptance. It could be. But it must ultimately meet that the test of the Contract Act Section 7 read with 13. Was there an intent to unconditionally accept the arbitration agreement and the main contract? Because what is also now happening is another complication. Parties are being joined to arbitrations on the footing that they are parties to the arbitration agreement. But the question of liability under the main contract is being left open. So you may have a situation where you join a party, participates in an entire arbitration, having to read evidence, etc. And at the end of the day, it's found that the contract doesn't hold him liable to anything.
So, Mr. Khambata, the first point which we identified was the actual or presumed intention of the party as rights of non-signatories to participate in the arbitration agreement. Right?
Yes.
Second was participation in the execution of the contract.
Yes.
Third was participation in the performance of the contract.
Yes.
Which are the other features then?
Yes. The second is performance and in the dispute also.
Participation in the performance.
Performance and dispute. There must be some, as my Lord said, the dispute must be that you made the representation to me. Therefore, that is the dispute. It can't just be, because equally the flip side
Then
is,
there's a third. Then what else?
then if you go to the next page, para 490, just because there is a group of companies is not per se a sufficient element on its own. Then 491 really goes back to reiteration of role in performance that we've seen. But if we see 492, the fifth factor, rebuttable presumption if it's a subsidiary, but provided that subsidiary participated in performance of the contract. Then 6 and 7 are found in para. That the party did not consider or care really. That's the example that fell from my law. That it's a group, you're really dealing with the essential party, you don't care who actually signed. But that has to be proved, it can't just be us. Then 7 is that all the companies concerned have participated in the rights and obligations of the contractual relationship. That's the underlying contract. Must be rights and obligations. My Lord has referred to a theory of estoppel, the benefits estoppel theory in America. So if you get benefits, then you are estopped. But here for group of companies, it's rights and obligations, both of the underlying contract. Then factor 8 is in para 496. The right to use a group or corporate structure. That is respected. It's not that is just overridden. Because you may, with open eyes, contract with one member of the group, knowing that the technology comes from another member. You don't insist on contracting with the other members. Later on, you can't say the other member is more creditworthy, therefore I'll go against it. And 9 is, does the test work both ways? Would you have made this person a non-signatory claimant? Would you have allowed it to claim against the signatories?
That's the 9th.
That is the 9th, the last paragraph. The reciprocal test. Would you have allowed it to claim?
The 8th one?
Case by case. Because in a given most important 490 that merely because
Yes, repeat the 8th point.
the 8th one is in para 496. There is a right to use a group structure. They recognize a right.
Okay.
Otherwise, the whole basis on which today in the corporate world, including within India domestically, companies are organized would be And I just want to point out why one has to be a little cautious. The author analyzing American case law has said there are two theories of estoppel. Benefits estoppel, where you get a benefit but you keep out. There he says the non-signatory can be there. But intertwined estoppel, which is like our composite performance, he said that can be used against a signatory, not against a non-signatory.
This is important.
Because he's not fair that a signatory portion. Now, my lord, with that, may I go to the promoter's point? Because I think that is a point that.
But you are telling us something at 417.
I'm sorry.
You are showing us something.
Yeah, I'm sorry. May I just show that? I'm so sorry. 471. I should have shown that.
That's an article in your.
That's an article which is relied on by our lordships in.
John Felazar.
That's right.
That's
But he was a colleague of mine during the LLM. Now, the first paragraph. This article is about non-signatories to arbitration agreements. The issue I address concerns a difference in the approach taken by US courts when a non-signatory seeks to rely on an arbitration clause against a signatory versus when a signatory seeks to rely on an arbitration clause against a non-signatory. When it comes to one particular non-signatory theory, the intertwined claims estoppel theory, US courts hold that a non-signatory may rely upon an arbitration clause against a signatory, not the other way around. Now he gives a reason for that. And that reason comes at page 473. On the third column, and then going on to 472. 473, the second last paragraph starting, it is submitted therefore that the rationale for the intertwined estoppel theory has little to do with estoppel, as it is traditionally understood, but rather is to ensure that parties to arbitration agreements do not undermine their effectiveness by commencing collateral litigation about disputes subject to arbitration. After all, when parties commit themselves to arbitration, they are agreeing to resolve a dispute by arbitration instead of litigation. If parties to arbitration agreements were permitted to avoid their obligation to arbitrate by suing a non-signatory on a claim intertwined with a dispute governed by an arbitration agreement, this would undermine the viability of the arbitration process. What would be the point in agreeing to resolve a dispute by arbitration if full-ball collateral litigation were an inevitable feature of it? While this account of the rationale for the intertwined estoppel theory makes sense as a matter of policy, it brings us back to the fundamental question that we raised at the outset. Why does the intertwined estoppel doctrine operate as a one-way street, stopping only signatories but not non-signatories? After all, if a signatory should be compelled to arbitrate with a non-signatory, when the dispute between them is intertwined with a dispute subject to arbitration, why not the other way around? The reason lies in the foundational principle of arbitration, namely, it is a matter of consent, not coercion. And therefore, he says, by signing an agreement, you have consented. You can't then back out of it. The non-signatory has not consented unless you establish his consent independently of this doctrine, of course. Now, my lord, to proceed now to the very good question on promoters, my lord. And I've covered that in this very note at the bottom of page 6. And in para 32 of the supplemental note, I have referred to the doctrine of single economic entity. In my previous note, I'd shown the varying views that different jurisdictions have on this. It's not a universally accepted doctrine. But even within our law, it is well settled that persons are entitled to arrange the affairs of its group within the confines of applicable law, as long as such arrangement is bona fide and not with a view to circumvent the law. And that Vodafone, and well, of course, Azadi Bachao, albeit in a tax planning sense. So as long as there is no fraud or circumvention, that's perfectly permissible. And then, therefore, the court. No. Yes. I'm sorry, I stand corrected. There's a mistake here. Would my lord please note this is not a quotation. Even though it's an item, this is my submission. It's come incorrectly at top of page 7. My learned junior rightly points out. It should, because there's no footnote, or it really should come as my submission. It's not a quotation. Thus, where there are pre-existing companies forming part of a group, a phrase used colloquially, and contractual obligations are assumed only by certain companies forming part of the group being a signatory to the arbitration agreement, it would be impermissible to join a non-signatory forming part of such group to the arbitration proceedings without the non-signatory having voluntarily assumed the obligation to perform the terms of the contract and having assumed the mantle of a veritable party. This is a key ingredient. That's my submission. That's not a quotation. Now, my Lord, the question that fell from Justice Roy is squarely answered in my respectful submission in para 35 of this note. My Lord put to me, and this is a question that Justice Suryakant had also posed in Cox and King, that you have family companies. You have companies where promoters are controlling a whole group. So can you reach out to the promoter? Can you reach out to companies within the group? Now, there are a few cardinal principles have to be kept in mind. First is that the ownership of a company, shareholding, is distinct from its management, which is the board of directors. And that, of course, for LIC Escorts downwards has, my Lord, held that principle very squarely. They are two separate organs of a company. But who has the right to actually administer and run the company? That's the board of directors under section 179(1). Promoters are not given such a status under the Companies Act. Many obligations are imposed on promoters under the Companies Act and other statutes like SEBI, but they are not conferred with the right or the status of control, per se, as a promoter. If they have a sufficient shareholding, then as Escort says, you can remove the board of directors, appoint your own board of directors. But the company is run through its board of directors. So to reach out to a promoter would really require a piercing of the corporate veil. It's not part of a group of companies approach. It has to be then a piercing approach that you form this company as a matter of fraud or circumvention of the law. You are the alter ego and we are reaching through. That is always permissible, but it cannot operate under the group of companies which respects the corporate veil. In subparagraph 3, I have said a promoter does not ipso facto control a company, and there are several sections of the Companies Act which show that. I don't need to trouble myself. Then 4 is very important. This would A for sure apply to large public and listed companies, since the doctrine of identification does not apply to such companies. Now, this in the Reliance matter, if my lords would kindly see in the compilation. This is a very salutary principle, because what happens is sometimes promoters in family companies enter into family arrangements or deals with members of their family. Now, if that concerns shareholdings, even large shareholdings in listed companies, the question is the listed company bound by that? Are they identified with their promoters? And your lordships have had no. If they are public and listed companies, you can't just identify them with the promoter because there's a large body of public shareholders. Because tomorrow, if that identification is permitted, a family member will say, I am entitled to enforce the rights I have against the company, and the company must comply, which is a public company. And therefore, in the Reliance case, I'll just see that in my compilation at page 1457, the big compilation. It starts at 1415 of the big compilation. And the first relevant para is para 58 at 1457.
Yes, the brothers, right.
58. Firstly, the MOU is not technically binding between RIL and RLI. It is not in dispute that the MOU is between 3 persons, and the personality of the company must be construed separate from 3 persons. The principle emphasized by senior counsel, i.e. doctrine of identification, may be applicable only in respect of small undertakings. But in the case of RIL and RNRL, the companies have more than 3 million shareholders. In such a situation, one cannot make the company's personality the same as that of the persons involved. And then at page 1519, paras 310, 311, senior counsel went to some lengths in arguing that the doctrine of identification has immediate and crucial relevance in this case. As explained by him, there are certain individuals who are the controlling mind of the company, and that once they have agreed to something, it should be deemed that the company also agreed to the same, including the board. Reliance was placed upon the decisions referred to in the summary of submission. In the instant matter, his argument was that inasmuch as MDA had agreed to the gas supply agreements as provided for in the MOU, it should be deemed that the board and the company also agreed to the same. Consequently, his argument is that the MOU is binding on RIL. We disagree. The doctrine of identification as developed by the courts is typically applicable in criminal and tortious liability cases. Even assuming that it is applicable in matters such as this case, nothing really turns upon in the factual matrix of the case. It is the fact that the board in mid-2004 had vested a substantial portion of its powers on MDA, but retained the powers that only it could exercise. The crucial fact is that ADA had agreed that the agreements entered into with MDA as a part of the MOU be mediated through the board in the form of a reorganization, and the board thereafter acted independently. This is amply evidenced by the board insisting that government approval is necessary. So again, on a case-by-case basis, but where the board retains its independence, it can't just be bound by a representation or an agreement by its promoters. Because in that sense, the promoter has obligations, but he doesn't have the right of control. And he can't bind a listed company or a public company. Therefore, this, my lord, is the answer of promoter. Now, may I take my lords only to a few more things, or not, I'll be done. Okay. One of the other clues on promoters is something I've dealt with and set out in my main submissions, which is under the Specific Relief Act, Section 15. Under the Specific Relief Act, it is expressly enforceable to enforce a pre-incorporation contract made by the promoters against the company. My lord, would kindly see Section 15 of the Specific Relief Act. Who may obtain specific performance? Except as otherwise provided by this chapter, the specific performance of a contract may be obtained by A, any party, B, representative. And if we go straight to H, when the promoters of a company have, before its incorporation, entered into a contract for the purposes of the company, and such contract is warranted by the terms of the incorporation of the company. So the company can take advantage of a pre-incorporation contract entered into by its promoters. The flip side of this is in Section 19. Who can enforce it? Against the company. When can it be enforced? Against the company. So 19. Except as otherwise provided by this chapter. Specific performance of a contract may be enforced against a party, etc. And then we come straight to E. When the promoters of a company have, before its incorporation, entered into a contract for the purpose of the company, and such contract is warranted by the terms of the incorporation, the company. So if the promoter pre-incorporation has made representations, entered into an agreement binding the company, that can be enforced against the company. But post-incorporation, merely because the promoter has even entered into an agreement which purports to bind the company, that's not good enough. And every party contracting is deemed to know the law. They know the promoter has no right or authority in law. They know it's only the board. Unless the promoter has a specific power of attorney, which is of course a different circumstance completely. So the concept that once a promoter has made a representation or an agreement, the company is bound, may apply to a very small company where the promoter is held to be the alter ego. But the moment it is a public limited company or a listed company, and there are public shareholders, that umbilical cord is broken. It can't be imputed to the company. Apart from which the board now has requirements of independent directors, etc. I mean, there are a couple of other points that may arise. it fell from your lordships, I'm told, the impact of sections 91 and 92 of the Evidence Act. Because as far as signatories to a contract is concerned, is concerned, it's very well settled that that intention has to be garnered from the contract itself. And if my lord kindly turn to my main note, the first submissions at para 67, page 70. I've just analyzed and summarized the law there. Para 67, it is well settled that the intention of the signatory must be deciphered primarily from the language of the contract itself.
Which page are you on?
Page 17 of the
Original
main submission.
Yes.
I've cited just the judgment in Bangalore Electricity Supply Company.
Yes.
Intention of parties must be understood from the language they have used, considered in the light of the surrounding circumstances and object of the contract. That's very well said. So as far as signatories go, when you're asserting mutual intention, one will look at the contract. You can really not look outside the contract or add a term to the contract.
Yes.
Or but as far as non-signatories are concerned, like they've not signed it, that may not be a repository of their intent. So it's only for non-signatories that all these factors then come into play. Now, why is this important? Because if in a given contract, the signatory's intent is garnered from the contract as limiting the arbitration to the signatory parties. For example, if the clause says between the executing parties, disputes between the executing parties, or between the parties, and parties is a defined term and is defined very clearly, it's then not possible to impute all these factors to impute an intention on the signatories. And the doctrine requires mutual intention of not only non-signatory but the signatories as well. Everyone has to have the same mutual intention. There has to be a consensus idea. So the means of ascertaining that is different. Signatories has to be ascertained from the contract, and 91, 92 would not be a bar where the intent of the non-signatories. But it would be a bar where the intent of the signatories. And which is a critical component of establishing mutual intention. Page 18, I've made one other point. It's just to put it in the perspective. My lords have, in decisions, very clearly, in para 70 of my note, laid down tests for even implying a term into a contract. So they're very rigorous tests. The official bystander test, the penta test in NABAPA, etc. Now, if that is the level to which a test is applied for implying a term, then surely implying consent of a non-signatory has to at least stand to some rigor. It can't be just brushed aside by saying he's in just because he's part of a group. Now then, my lord, I'm again not troubling my lord in the next section under direct relationship. I've given indication of judgments of other countries which have not accepted the single economic entity principle. So England has not accepted it, Bank of Tokyo Karun, Singapore has rejected it. And Singapore has rejected it on the grounds which I've set out in para 75. That one, it would be anathema to the logic of consensual basis of an agreement to arbitrate. B, ordering of companies within a broader group did not mean that one could dispense with separate legal entity. And C, if the doctrine was accepted, all one-ship companies would be considered as part of the same single economic entity, resulting in the liability of a one-ship company being visited on several or all of its other one-ship sister companies. Now, Singapore is one of the most forward-looking pro-arbitration jurisdictions, but it has not accepted this. England, of course, your lordships know, in Rukhsar and Searle, wholly owned subsidiary was not held to be part of the arbitration agreement. Was held to be a party. And Swiss law also, in para 77, the fact that one legal entity controls another is not sufficient to reverse the presumption that only the entity that Vodafone, then I've cited, I've shown that my lords are familiar with. Then para 79, a passage from Gary Bond, which is also instructive, and I'll just quote it from here. All of this is found in my convenience. I'll just quote it from him. Quote, Gary Bond provides that the group of companies doctrine provides that a non-signatory may be bound by an arbitration agreement where a group of affiliated companies exists and the parties have engaged in conduct such as negotiation or performance of the relevant contract or made statements indicating the intention assessed objectively in good faith that the non-signatory be bound and benefited by the agreement. It's not enough to have a group. And this is a very important factor which is often missed by tribunals heated in India. It's just not enough to just see a group. We have to satisfy further requirements of society. Then, my lord, I won't trouble my lords to read the commonality of subject matter and composite transaction. My lords, that's the principle of Olympus superstructure. You have a mother agreement, ancillary agreements. Chloro controls in Paris 73 has adopted that. But going to the next page, page 21, the participation, the predominant participation of the non-signatory is critical. So, Dow Chemicals we have seen. Para 85, Redfern and Hunter. Question is whether the non-signatory actively participated in the conclusion and execution of the contract containing the arbitration agreement. And your lordships have also, in Reckitt, Cheran and Canara Bank, considered these factors, such as negotiations, execution, performance, as key determinants of intent. Of course, every case will be on its own facts. I'm not for one moment suggesting that will not. And therefore, the involvement of the non-signatory in the negotiation of performance should be such that the non-signatory has actively assumed obligations of performance upon itself under the contract or chosen to be bound. Then one can say there is an implied acceptance under the contract, by contract. But a sentence here or a sentence there referring to the non-signatory can never satisfy the test of implied acceptance under the contract. And in Dalla's case, which I've earlier shown, but this passage I had not shown, but I'll just read it from here. Para 88 I've quoted. Dalla goes into this question. The UK Supreme Court says, 1, subjective intention based on objective evidence must show a conscious and deliberate act of involvement. And 2, additionally, if direct involvement in the negotiation and performance of the contract is by itself said to raise the presumption of a common intention that the non-signatory should be bound, it set an unworkable low threshold which would raise a presumption that many third persons were party to contracts deliberately structured so that they were not party. So, by merely saying involvement in negotiation and performance, in fact, you may defeat the whole intention of the contracting party. Because it may be one thing when they enter into a contract. After a few years, one of the parties wants to make some claims, may suddenly decide to the contrary. But he must be bound to his election at the time of the execution of the contract. He consciously left out some companies. So all this has to be seen. And the test ultimately boils down to this. Are these factors or circumstances enough to impute an implied unconditional acceptance by the non-signatory of the arbitration clause? If they are not, then you can't draw on a non-signatory merely because it's part of a group of companies. And therefore, in para 92, for example, I've given some examples of the other way. So one would be mere incidental involvement in contract negotiation or contractual performance is insufficient. That's from Gary Bond. I've quoted from there. Then next in B, companies' awareness of a contract, including an arbitration clause between other parties, and its confirmation of one aspect of the underlying contract does not necessarily make the company a party to the arbitration clause. Let's take a case where a company A, which is part of a group, enters into a contract with company B. Company A takes on a variety of obligations under the contract. One of those obligations is stated in the contract that it will be performed by company C, which is part of the group. That doesn't make company C a party to the arbitration clause in the contract, because it can't be said that party C, by its conduct of doing one aspect of performance, has accepted that it is a party to this contract. Therefore, again, case by case. And a non-signatory without any causal connection with the process of negotiations cannot be made a party. These are all these are not my ipse dixit. I've taken them from commentators. I've just gathered them together in one paragraph. And I've footnoted where the. No, I'm not troubling my lord with the next 2 pages, which is all the various theories. And in fact, when I read my learned friend submissions, there are many more. There's some 10, 12 theories. They're always theories. But each one has its own safeguards, qualifications, etc. Then we come to page 25. I've sought to answer the questions posed in Cox and Deals. The first question A, whether the phrase claiming through or under in sections 8 and 11 could be interpreted to include the group of companies doctrine, and whether the group of companies doctrine should be read into section 8 of the Act, or whether it can exist in Indian jurisprudence independent of any statutory provisions. For the reasons set out in paras 50 to 58, persons claiming through or under in sections 8 and 45 cannot include the group of companies doctrine. The phrase is restricted to derivative claims, and the cause of action must vest only in the signatory party. That I covered on the last occasion. Then question B, whether the group of companies doctrine should continue to be invoked on the basis of the principle of single economic reality. It is submitted that the doctrine should not continue to be invoked on the basis of principle of single economic reality alone for the reasons set out below. First, multiple jurisdictions have rejected the concept of single economic entity on the ground it vitiates the most fundamental principles of company law. In India, piercing the corporate veil, as stated above, is subject to satisfying certain stringent conditions. Second, the group of companies doctrine being a consensual theory is premised on the existence of a dispute arising from a defined legal relationship and mutual intention of parties. Sans intent, the application of group of companies cannot be invoked. Third, the jurisprudence around group of companies has entirely ignored the concept and definition of a group, and will not have referred to the accounting standards, where the group is defined as a parent with all its subsidiaries, and subsidiaries in turn is defined as an entity, including an unincorporated entity such as a partnership that is controlled by a parent. Control refers to the power to govern the financial and operating policies of an entity so as to obtain benefits. So it's not merely shareholding, it's to show actual control. I've also referred to the RBI master directions around this. And then para 103. Given the broad definition of group companies and control in modern day complex company structures, a network of multiple entities across jurisdictions, one common ultimate parent or common parent shown at the top, may all be categorized as group companies, despite the fact that they have their own independent management and operations. The concept of a single economic entity may be viable in case of small family group structures, but would not stand water when looking at large group structures and transnational corporate groups. It is therefore not in line with today's economic reality. Otherwise, corporate structures that are common would automatically result in numerous companies being joined to arbitrations concerning just one or a few of the group. And this would render arbitration completely inefficient and unwieldy and undermine the independence of the legal entities and their party autonomy. Then 105 I've already dealt with in detail about the promoters. I'm not repeating it. At 107, my lord, I've referred to the test of tight group structure in the MTNL case. Again, saying that can't be the sole basis. That may be one of several factors, but that really can't be the sole basis for imputing the group of companies doctrine. Then page 27, question C. Whether the group of companies doctrine should be construed as a means of interpreting the implied consent or intent to arbitrate between the parties. Whether the principles of alter ego and of piercing the corporate veil will alone justify pressing the group of companies doctrine into operation even in the absence. Ranging from one of the first expositions in Dow Chemicals to chlorocontrols and Cheran, throughout the literature enunciated by Russell, Bond, Redfern Hunter, Hanushu, across the law propounded in various developed jurisdictions globally, the key theme that runs through group of companies is mutual intention. My lords have seen that. Therefore, group of companies must continue to require this key element. It can't be discarded. Implied consent or mutual intention, what I've referred to in para 109, that is of all signatories and non-signatories. In 110, it is, as my lords have held in Cheran, group of companies is distinct and independent of theories of alter ego and piercing of the corporate.
That's 112.
At page 28. Whether the group of companies doctrine is expounded by chlorocontrols and subsequent judgments is valid. Now here, I have suggested, my lord, that there must be cumulative conditions, including the condition added by my lord in ONGC is performance, involvement in negotiation and performance, which is not there in chlorocontrols. And mutual intention, again, my lord, I have said, language of the agreement is primary. A bit of a repetition, I don't want to, my lord, read this. Then, my lord, page 29, there is observation by Justice Suryakant that there's some contradiction in chlorocontrols, because in one paragraph, it is referred to as a clear intention of parties to bind both signatory and non-signatory. The next paragraph says a non-signatory. This is at page 30 of my note. I've given the extracted one. A non-signatory would be subject to the arbitration without their prior consent. But this would be only in exceptional cases. I would submit there's no real contradiction there. Because when prior consent is referred to in the context of non-signatories, it obviously means implied consent. It can't mean by signature or in writing. No, therefore, I don't want to trouble my lord with the rest. I've given a short answer, but really my submission is this, and I end with that, my lord, that it is critical to limit the doctrine. If my lords are minded to at all included under section 7, it must be limited to the parameters of section 7, which is a concluded contract valid under the contract. It can't be otherwise. Otherwise, it falls out of the whole scheme of our law, both under the Arbitration Act, the Contract Act, Section 28 of the law, and which would require unconditional local acceptance to be determined, even by. I'm deeply obliged. I'm sorry, I've taken a little more time than I thought I would have.
My learned brother has a question.
Of course.
Could this also lead to opening up at the behest of a third party innovation?
It's a very good question. My lord is right. A third party who is not a signatory can say either that it is a party to this contract or that there is a separate contract which replaces this, which is novation. All sorts of complications could arise.
So it can, according to you, provided it satisfies 7 and 30.
Then it would have to still satisfy the Contract Act test.
An open end.
It would really open up. My lord is absolutely correct. It would really take it far beyond what was intended.
Therefore, this definition of contract being a written contract has provided.
But there is one caveat I might add, my lord, to my answer. There's one caveat that if it's a ratio, then even the arbitration clause is novated. Then he would have proved that the novating contract has an arbitration agreement. So a full-fledged novatio may then, in fact, undermine the whole.
Thank you, Mr. Kumbhata.
Thank you.
Now, who will be addressing after this? Mr. Rai will begin first.
Lord, I appear in the first matter for the respondents, Lord, is a section 11 being filed by Cox and Kings against SAP India and SAP Germany. And Lord, I'll just quickly address my Lord Justice Simha's last question, Lord, because, and I won't take my Lord your Lordships through much of the facts of our cases because your Lordships are deciding the matter on principle. But some illustrations would always help, my Lord, how these principles apply in the real world of commerce. And my Lord, in my case, in the lead case, my Lord, Cox and Kings entered into a license agreement with only SAP India in 2010. And that license then, my Lord, grants them whatever softwares they want to get as licensees. It has an arbitration clause. And since it's a license, the arbitration clause is an ICC institution arbitration clause and says that the arbitrators, other than the chairman, shall be persons well versed in computer science or technical aspects of the law. It's got a specific qualification for the arbitrators. Now, under that license, Cox and Kings licenses various softwares from time to time. A wholly separate agreement is entered into 2015, where they license one more software from SAP India and want the services of SAP India to install license. That services agreement is also only between SAP India and Cox and Kings. Specifically says it's an entire agreement. Has a very different arbitration clause. Now, the disputes are SAP India actually commencing an arbitration against Cox and Kings. Cox tries to resist that arbitration, saying that the agreement is null and void, the services agreement. Then Cox and Kings goes into insolvency. And 2 days after it goes into insolvency, it commences an arbitration under that very services agreement it said was null and void against SAP India and also now SAP Germany. And it says it is commencing it against SAP Germany because at some stage when the services agreement was one official of SAP Germany wrote an email saying we'll try and address the problems. And Mr. Advani, that email, according to him, meant that SAP Germany has not taken over the contract. That's one of the digress to start is because in substance what they're arguing is some type of performance, in this particular case, an email written by one official novates the contract in favor of SAP Germany. I hope I make myself clear.
Yes.
And the reach, my lord, as my lord just said, my lord, this is very, very open-ended. In the context of agreements that are subject matter of has entire agreement clauses. The clause says, my lord, it's an entire agreement. The agreement also, my lord, your lordship, 16 times without number, says it can be amended only in writing agreed to between the parties. I show those kind of illustrative agreement clauses. Because, my lord, fundamentally what is being argued, my lord, is that the agreement is now being amended or an implied term is being read in. And my respectful submission, my lord, as my learned senior friend, Mr. Samata, just briefly raised, the test for reading an implied term is a very, very high test. I'll come to that, my lord, from Nabha Power. The word business efficacy, my lord, Chief Justice has used in some. That is, my lord, when your lordship finds an arbitration agreement and then wants to give it business efficacy. So, my lord, in IS form, when your lordship use, your lordship says, please can't defeat an arbitration agreement by just saying, and then taking it out of arbitration. But the context in which your lordships used business efficacy was, there is an arbitration agreement, and your lordships are trying to give effect to that arbitration agreement. Today, my lord, business efficacy is being used to say that parties which have not signed any agreement are somehow to be brought in, not by virtue of Section 7. I stand entirely with Section 7. You don't have to be a signatory. It can be incorporated by reference. But, my lord, the group company, as I understand it, goes much, much further than Section 7. It says that without following the procedures of Section 7, you can be a party to an arbitration agreement. How? By there being some commonality in the transaction. I'll come a lot to the details. But by there being some commonality in the transaction, agreements cannot be implemented one without the other. So, my lord, in many respects, my lord, almost like a party claiming through and under, I take a lot of Mr. Kamata's submissions. A lot of his submissions, my lord, I adopt. But according to me, my lord, as an arbitration practitioner, trying to, my lord, set sound arbitral practice, that leads to the conclusion that Section 7 must be applied. The group company doctrine, my lord, may not be an appropriate doctrine to find parties to an arbitration agreement. Well, the way I propose to proceed is, there are various issues at play here. My lord, where your lordships have already engaged with the issues, I would only state my point. But where, my lord, there is a different perspective I wish to bring, my lord, I'll bring that point. And I'll largely follow, my lord, my written submissions, even though, my lord, they have evolved through the course of your lordships hearing this matter. My lord, the way I propose to proceed is this. I want to take your lordships, my lord, only to Dow Chemicals initially and chlorocontrol, because that is the fount of this doctrine. And my lord, Dow Chemicals, I assure your lordships, is applying French law, which specifically says there is no form of an arbitration agreement. And then I take your lordships to chlorocontrol to, my lord, examine whether chlorocontrol made certain persons party to the agreement by virtue of the phrase claiming through or under, or by incorporation of the agreement contained in the mother agreement to, my lord, ancillary agreements. I'll formulate that. But, my lord, after examining that, I will take this matter on a clean slate. Can, my lord, the doctrine find its place in our Arbitration Act, in Section 7, in 2.1, or even in 8 or 45? And, my lord, my submission would be that to do so would violate, my lord, the Arbitration Act, the Contract Act, and also the Companies Act. But the same result or a similar result may be reached by applying Section 7, by applying the group company doctrine. And one other aspect that has been touched upon, but not fully perhaps, is in these cases, are we talking about joinder of parties? Are we talking about consolidation of persons? Or are we in fact saying that some persons are necessary and proper parties, and therefore, my lord, even though they are not parties to the arbitration agreement, we must find a way to bring them here. And, my lord, the submission is this, that there is no doubt, my lord, that we must give the Arbitration Act its full meaning. And we must, in fact, my lord, endeavor to reach an interpretation that makes India arbitration-friendly jurisdiction. Or more than that, my lord, a jurisdiction that supports commercial work, and including commercial dispute resolution. But, my lord, with all humility and with all due respect, my lord, I submit that the group company law may in fact do exactly this. My lord, I don't want to, my lord, in a bench before I am, my lord, I don't want to, my lord, make this a partisan case of arbitration. But, my lord, it is a good example. It is a good example of a company sitting in Germany, not signing any contract. An email is authored saying we understand there are problems in services contract between SAP India and Cox and Kings. It will be looked at. Now, my lord, kindly appreciate, and again, my learned senior friend made these points, my lord. This official by email cannot be, my lord, binding SAP Germany. Kindly see, my lord, the reach of what the group company doctrine in that sense may be proposing. And there will be examples and examples, my lord. I confess that there are some hard examples, and there would be examples across the, my lord, range. There would be, in a sense, a use of the group company doctrine. There may be a misuse of the group company doctrine. But, my lord, the doctrine as formulated may not be susceptible to this kind of use or if I may, my lord, misuse. Because, my lord, performance is, when do we say, my lord, the company has performed the contract? In Dow Chemicals, my lord, the other entities of Dow Chemicals were actually distributing goods through that distributor, Saint-Gobain. It was that corporate entity that was actually doing the distribution. It wasn't some parent company's official who just stepped in. And the same test would apply, my lord, for negotiation. Often, my lord, in negotiation, you would, my lord, someone from the parent company may also come. But the ultimate test is, if that parent company was going to be bound by the contract or the arbitration agreement, I appreciate, my lord, those are two separate inquiries. Why would the parent company not sign that contract or sign or by an exchange of letters or by incorporation, incorporate that arbitration agreement. But kindly see again, how does a parent company contract out of this? But other than its subsidiary signs an agreement. That agreement is an entire agreement. That agreement says it can be amended only in writing between the parties. Now, in that context, Lord, how is the parent even to contract out? Because it is never contracted in, is my respectful submission. So, my Lord, I want to say, my Lord, although I am contesting the group company doctrine, it is actually because I am not that pro-arbitration. Unless there is clarity on who the parties are. Of course, my Lord, Section 7 will come up for interpretation in cases before this Honorable Court and in other cases. But, my Lord, that Section 7 itself provides the clarity. Within that also there can be context. But the group company adds a layer of, my Lord, uncertainty without, my Lord, in my respectful submission, any statutory basis. And, my Lord, the further submission I will make is that the Arbitration Act or the arbitration procedure should be agnostic to whom are the parties. It should not be, my Lord, that if I take my arbitration to the ICC institution, I get a different result as to who are the parties. Whereas if a party files a suit and a Section 8 is filed, a different result comes. Or under Section 11, a different result comes. And I would not submit that this interpretation, this application of the group company doctrines may in some cases lead to that kind of contradiction. Where, Lord, if it's a CIAC arbitration, a different result would ensue, whereas if it emanates out of India or in a second, a different result may ensue. And, Lord, all this is also very relevant in the context of, Lord, the Law Commission report. And the Law Commission report recommending the amendment to the definition of party and that amendment not being taken into account. But Lordship would be aware that in the same Law Commission report also recommended the amendment to the definition of an arbitration to include the order of an emergency arbitrator. The emergency arbitrator in his public, nicely commented in his emergency award that that was not implemented by the central government because that would be like gilding a lily. The arbitral award always involved included in emergency. But look, this would not be such a thing. Here, definition of party that does not include the words claiming through another. We have a definition of party that is different from the English article, which too does not accept the group company doctrine, despite that broader definition of party. Even there, the group company doctrine is not accepted. With that preface, and just 2 or 3 illustrations with this, raised, I think, a basic case where it comes up, agreement between a principal employer and a contractor, and the contractor in turn subcontracts various aspects of his work. Now, both these agreements have separate arbitration clauses. In fact, when we appear for a contractor, sometimes there is no defense to the principal employer because our subcontractors indeed delayed work. It sometimes becomes a difficulty when you're appearing from a contractor sandwiched in that sense between a principal employer and a subcontractor. I'm sorry. But in my respectful submission to two separate contracts with 2 separate arbitration clauses. And therefore, the arbitrations would have to be and so, the last aspect of my submissions will be, judgments which have followed. Because in my respectful submission, Amit Lalchan may have gone one step too far where there were not even group companies where it was brought in. And so too MTNL, where Canfina was not a party to the arbitration agreement. I'll briefly take you through that. But Cherin was correctly decided because Cherin was deciding a case of Section 35 and when a person would be bound by an arbitration agreement. And there, my lord, Chairman, and I'll show that, my lord, was a clear nominee of the person who had signed the agreement. Chairman, my lord, bought the shares as a nominee. And similarly, my lord, the decision in ONGC versus Discovery was, my lord, correctly decided for this reason, that ONGC was seeking to bring in a party on the basis of alter ego. Therefore, my lord said that before you decide the Section 16 application of that party, you must hear ONGC's application for discovery of documents. So, my lord, in that sense, the result was, in my opinion, the correct result. He said, establish that the counterparty to my agreement will know of one other that seek to impede in this arbitration. So, the judgments that follow. No, with that broad preface, my lord, and only because I'm the first to be arguing, my lord, against the group company doctrine as it were, my lord. I have also, my lord, and I will make submissions how it narrow. But in the first respect, the approach I would, my lord, commend to your lordship is that the very text in the reading of sections, your lordships would, my lord, deal with who is a so define the application. My lord, just 2 or 3 words.
No. Now you really, because you are the first person who's saying that, well, don't apply the doctrine at all.
Yes.
So maybe we can come back at 2 o'clock.
Lord,
Tell us what is your estimate?
both of us.
So how much time would you like?
Both felt we need an hour and a half each, my lord, spill over into tomorrow.
So because you start at 2 o'clock, then at 3:30 you should be done today.
Yes, yes.
And Miss.
And your lordship give us time tomorrow. Otherwise, we had agreed, my lord, we would share time if
And
your
then,
lordship us tomorrow.
But 3:30.
Yes.
Then you start at 3:30, and then you can finish by about, say, 12 o'clock tomorrow.
I think that should be it. That will be fine.
That should. And then that wraps up. Nobody else on this side,
I
right?
think Mr. Ghosh wanted to make, just additional submissions, if at all, Sanjoy Ghosh. And well, that's it on this side. And I don't think he's not here, but
Because we are rising. Because if Thursday is declared as a miscellaneous day for some reason, then tomorrow we'll have to wrap this up. And then we'll be able to wrap it up because the others then can give us a supplementary note or something.
501.1 minutes you want to address.
Yes.
Thank you.
Thank you.